好，咁我哋
All right, we have already formed a quorum, and it's the appointed time. Let's get started. First, confirmation of minutes of the last meeting. Meeting held on the 5th of January. CB bracket 1519. The Secretariat has not received any proposal for amendments so far, so let's confirm the minutes. Let's invite the administration team to join us.
Good
morning. With us today are government officials, and we have got the name list before members, so I don't think I need to introduce them. Basically, the same team is with us today. Response to follow-up issues arising from the discussion at the previous meeting. We have two papers. Paper number CB bracket 1521 stroke 14 to 15 bracket 01. So that's a list of follow-up actions arising from the meeting held on the 29th of January. And the second one is the government's response to follow-up issues arising from that discussion. So can I invite the administration team to walk us through the papers before the floor is open to members' questions? Thank you, Chairman. Concerning Clause 15 of the bill, which allows the Director of Electrical and Mechanical Services to have the discretionary power to reduce, waive, or refund in whole or in part a charge, fee, or deposit payable. Well, this is just a reserve power. We are not saying that we are sure that under a particular circumstance that the DEMS will have to exercise that power. In fact, in drafting this clause, we have also made reference to other pieces of legislation involving public utilities, including the Waterworks Ordinance, and we noticed that there is also a similar clause in that ordinance enabling the administration to have the flexibility to look at the situation on a case-by-case basis to decide if a waiver or a reduction is warranted. And members have also asked us to give you the criteria for exercising this discretionary power. As I just said, the power would be exercised on a case-by-case basis, and therefore it's difficult to come up with a hard and fast rule as to the circumstances under which the power will be exercised. Because if we put that in the bill, then that might also mean that if there are other circumstances warranting the same treatment, they cannot enable us to exercise that power. It doesn't mean that we have something in mind that we will be exercising that power. It's only a reserve power. So, concerning this explanation, any comments from members? Mr. Wu Chi-wai. Thank you, Chairman. Just a simple inquiry. So, according to the administration, there are similar pieces of legislation with a similar power. So, can you tell us that under the Waterworks Ordinance, in what circumstances has the Director exercised this power, so that we can be familiar with the circumstances under which the power might be exercised? So, Ms. Ma, thank you, Chairman. Concerning the Director of Water Supplies, it's hard for me to speak on behalf of the Director, but then in very exceptional circumstances where there are technical issues resulting in the Director who might think that he needs to exercise that power. But then with regard to the entire system of water supplies, it's somewhat different from this one, because under our case, in our case, we are talking about a brand new system, and therefore, given the differences in the two systems, to the extent that when the Director might need to exercise that power, we believe that there might be such cases, but then it would be somewhat different from that under the Waterworks Ordinance. But then if you look at the operational experience, given the fact that the two systems are very different, I don't think using that as an example might not be appropriate. Well, I'd just like to look at how that power might be exercised by other departments with a similar power. But then for any surcharge of water tariff, well, after your calculation under the existing formula, there might be mechanisms under which you can refund or offer a fee waiver to the user. So please think about it at the next meeting. You can also talk to the Water Supplies Department to see if they have got similar experiences or examples, so that we can have a better idea of the situation under which you might be exercising that power. So we will be able to tell whether or not the drafting of that clause might result in a director not being subjected to any restraint in exercising that power. Well, my personal view is that we need not worry too much about this, because as far as the legislation is concerned, I also personally think that there needs to be a flexibility for the director to exercise that power. But then if you want specific examples, I also agree that there might be difficulties, because as Mr. Wu Chi-wai said, in terms of the charging of fees, if there is any query, then there are mechanisms available for the user to seek a review of the bills and the readings and so on. But then this power is there to cater for very special circumstances. I can also give you an example. I'm not doing this on behalf of the administration, but then I can also imagine that, all right, there are two parts to the fees and charges. First is the cooling capacity. So even if you don't use it, you will have to pay that. For example, for a building, because of the cooling supply system, well, if there are problems with regard to the government's system, for a long time, the administration is not able to supply cooling to that building, and for users, they are already victims of this. And under the clauses, even if they cannot use it with regard to the cooling capacity part, they will still have to pay for that. But then if there are problems relating to your system resulting in a loss incurred on the part of the users, then during that period of time, with regard to the contract cooling capacity, there should be a waiver or exemption on the fees and charges. So that is a situation that I can imagine. Of course, that would be very slim in terms of the possibilities of this happening, because there are different units supporting the supply of cooling to the building, and therefore the chance of the entire system collapsing would be rather slim. But then I can just come up with this example, and the Principal Assistant Secretary can also answer the question raised by Mr. Wu, and also the immature example that I just gave. All right, let me respond to the point raised by Mr. Wu with regard to miscalculation. In fact, on miscalculation, we all know the criteria of the fees and charges that has been set out in the bill, and if the user thinks that there might be a wrong calculation, then they can always seek a review, and of course if it's wrongly charged, then of course that would have to be refunded. So that would have to be adjusted. But then that would not involve the use of this discretionary power to adjust the fees and charges, because if it's an excessive charge, then of course that will have to be refunded or reimbursed. But then in this case, we are talking about a very exceptional situation. So it's not as simple as a wrong meter reading. So it must be a very special situation. So it's not similar to a situation whereby the meter reading is not consistent. What about the example that I just cited? Yes, Mr. Lai? I think what the chairman just said could be a possibility, but then that would be rather remote. In other words, we are not able to provide any cooling capacity to the building, but then of course in terms of the capacity charge, that could also be adjusted in the light of what's happened. In other words, So there is a need for this clause to be included in the bill. Yes, Mr. Wong Teng Kwang. Thank you, Chairman. For any fees and charges imposed by the government, well, there is always this reserve power given to the administration to enable the relevant director to have some flexibility in dealing with special circumstances. Well, mention was made about the Water Supplies Department, and if you want to get similar examples for the director to exercise this power under the ordinance, well, I don't think there would be similar cases. But then there might be situations which the director would also have to face. And if you ask me, I also have some personal experience, because for the WSD's water meter is, after all, a mechanical device, and it can also break down, and in some cases it can run through the roof, and my company was subjected to skyrocketing water tariff, and of course that's because of the breaking down of the device. And I therefore negotiated with the WSD, and then the director for water supplies exercised his power to freeze the tariff for the time being, so that I was not required to pay, because the amount was simply too high. And after the checking of the meter, it was found that indeed the meter was not working properly. That's why, in accordance with the historical charges, an average figure was taken. So that's the case in which the Director for Water Supplies exercised his discretionary power to waive some of the fees and charges. And I'm sure with regard to district cooling, the DEMS would also be facing similar situations, even if they might not be identical. And if we do not have this reserve power for the director, then he would be subject to a lot of constraints. So that is a concrete example. And for my case, I think it's just the tip of the iceberg. There must have been numerous examples warranting similar treatment.
So my understanding is that we do need that discretion. I have not suggested that we should take out this provision, but since it is there in the bill, I would like some examples. I think Mr. Wong's example, it's actually a personal experience on his part. So I think we all agree that it is appropriate that we retain this provision in the bill. All right. If there are no further questions regarding this paper, let's move on with our scrutiny of the bill. And last time we were up to part 5, which is about appeals. And last time our legal advisor raised a number of questions. And I don't think we finished with our discussion yet. So, Permanent Secretary, could you further explain to us and respond to the questions raised at the last time in respect of Clause 22? Legal advisor, could you, first of all, ask the question again. Last time we were scrutinizing Clause 22 of Part 5. Clause 22 provides for the grounds for appeal. And when we're looking at 22 to D, that is not to resume district cooling services to a building under Section 7(1) bracket B, C, or G, or to a building under Section 8 bracket 2 where the services were suspended. And so if you go to Clause 7 of the Blue Bill, you'll find that Clause 7 is about the circumstances under which the director may suspend or terminate the district cooling services. If we go back to 20, you'll find that DEF are missing. What are DEF? When the director thinks that when there's a need to make installations, or if there are faults in the DCS system resulting in emergency, and or if the director is of the opinion that in order to protect life and property there is a need to suspend or terminate such a service. If the director believes so, he may suspend or terminate the DCS services to the building. Apparently, if one looks at section clause 22, the grounds for appeal does not include the scenario where the consumer has an argument with the director according to section 7, 1, B, C, and D. The approved consumer doesn't agree with the director. So if there is such a dispute, can I rely on section 22 to lodge an appeal? And if so, according to which subsection of clause 22? And if not, I would like the administration to explain what is the policy consideration here and why it is not allowed as a ground for appeal. I was asking the administration to clarify on this point. I think here it talks about, where the operation might be affected or have to be suspended. Then why can't we also, invoke C, D, and F as grounds for appeal? In deciding which decisions could be subject to appeal, I think members would have noticed that under brackets D, E, F, we are talking about technical problems or faults. Under the circumstances, if the system is broken down, of course, the supply would have to be terminated. But under such circumstances, it may not be necessary for the appeal board to accept an appeal. Perhaps Mr. Lai could further answer this technical question. Chairman, 7.1d. It's about the need to carry out certain inspection or works for the system. And normally we would come to an arrangement with the end user first before we would proceed with the works. We will inform the user beforehand that we need to conduct such inspections or test or maintenance works. As for E to F, we're talking about emergency situations. Again, these are emergencies, and so D, E, F, therefore, are all about works that need to be carried out to ensure the safety of the system. And we think that, well, especially for D, we would certainly communicate with the user before we proceed with such works, because in the case of D, we're not talking about an emergency situation, whereas E and F would involve an emergency, and we need to ensure the safety. Question. Well, according to Mr. Lai, I think 7EF is about emergency situations. If we look at 7G, it says that if, in the opinion of the director, the behavior of or an installation of the building by the approved consumer for the building is jeopardizing or will jeopardize the operation or reliability of the district cooling services. If you go back to clause 22, I mean, this could be, a ground for appeal according to clause 22. If the director has this opinion that there is a need to suspend or terminate the supply. So G is also a scenario under which the director is of the opinion that there is a need to suspend or terminate the service. it would appear that I think the administration should further explain that. That is, if the government thinks that under Section 7, if Section 7 DEF are not included under the appeal mechanism under Clause 22, and if the end user doesn't agree with the director, are there any other channels for them to appeal against the decision of the director? Well, according to the text of 7DEF, there is no indication that they arises because of what the end user has done. And the legal advisor actually has asked the right question. According to DEF, it doesn't suggest that the problem is caused by the approved end user. But still, in the end, it involves the right of the user to use the DCS system. And if he cannot invoke this mechanism for appeal, then how can he take his case to appeal to? Well, under 7G, indeed it is true that if the director thinks that there's a problem with the behavior of the user, and then I think G could be dealt with by way of the appeal mechanism. The purpose of having the appeal mechanism, and if members would refer to 22(1), it says here that a person who is aggrieved by any of the decisions of the director of the EMS. Now, the whole appeal mechanism is set up to protect the rights of the end users. So what is the scope of the appeal mechanism? The appeal mechanism can deal with whether or not the director may allow an applicant to become an end user, as to when supply could start and when supply of the services could be terminated. Under 7DEF, they're about technical issues, and Mr. Lai had already explained to members. I mean, if the system breaks down, it has broken down. It's not. It has nothing to do with the decision of the EMST. So such scenarios do not happen very frequently. But in case there is a breakdown, and if the end user is inconvenienced, then it shouldn't be dealt with by the appeal mechanism. If there are technical issues resulting in the interruption of the supply of the cooling services, and the end user is affected and suffered a loss, then we believe that it shouldn't be dealt with by the appeal mechanism, but rather through civil litigation. Perhaps our colleagues can further elaborate on this point. Thank you. I think the Permanent Secretary is right, that is under the bill, and according to Section 7(1) DEF, the end user will not have any right to appeal. But if the user has suffered any losses, he can consider, lodging his claims through legal proceedings. I think what the user is most concerned about is the resumption of supply. He can actually apply for the resumption of the supply of district cooling services. Now, if the director decides to suspend or terminate the supply of services, then he can apply for a resumption of supply pursuant to Clause 8. And if indeed, in the end, the user may have to resort to civil litigation. I think the question here is whether or not he has that right. I think BCG under Section 7 all involves the end user. That is the answer, the user not complying with what is required according to the provisions of the bill. For example, failing to comply with certain guidelines, and the director believes that this may affect the operations or the reliability of the system. So as a result, it will not be covered by the appeal mechanism. Mr. Uchiwai? I have two supplementary questions. First of all, the suspension of service. Now, during the appeal period, my understanding is that the supply of cooling services would continue unless you say otherwise, saying that there won't be any supply of cooling services. But if cooling services were stopped, then the scenario under subclause G would pose a serious problem. G is about the installation of the approved consumer is jeopardizing or will jeopardize the operation or reliability of the DCS system. And also we're talking about during the appeal period where you still continue to provide the cooling services. So in theory, the problem will simply deteriorate. So in reality, would that be the case? And if you continue to supply the cooling services, and let's say the installation is, jeopardizing the operations of the system. Mr. Wu, I think we had a discussion already on this point at the last meeting. I think the situation is exactly the opposite of what you are suggesting. During the appeal mechanism, unless there's another decision, that it will not result in that decision becoming void.
So if you lodge an appeal, it wouldn't render the director's decision suspended. So it doesn't mean that as soon as you lodge an appeal, the supply will immediately resume. In fact, under 22.2, the situation being described here is exactly the opposite of what you just said. So you're concerned that whether or not the supply would be endangered. Precisely, that will not be the case, because an appeal under subsection 1 against a decision or a direction does not suspend the decision or direction unless the director decides otherwise. Yes, Mr. Chair, I'd like to clarify that under clause 22C and also 7.1b, it can also cover the fees and charges, right? Is that right? And of course, clause 15 says that the director can decide to reduce, waive, or refund in whole or in part the fees and charges. But then what if I pay more than I should? So what if I've been overcharged? Then can I lodge an appeal against that? So would that be covered already? Because you also talk about 7.1b, and that would also have to refer back to section 4.2c. So as an application, if you're still using the services, then you will have to pay all the fees and charges due to you. So in simple terms, what if I am overcharged? If I pay more than I should, then is there a mechanism under which I can lodge an appeal? I think Mr. Wong Teng Kwong has already referred to a similar experience. So he was overcharged as far as for water supply. Well, if the consumer suspects that he has paid more than he should, then you can always ask for a testing of the meter, and I'm sure the EMSD will test the meter for the consumer, and if it's found out that the meter was not working properly, then of course adjustments will be made to the fees and charges. So is it that the director's decision will be final, and the mechanism does not include that? So even if I'm not happy with the fees and charges, if I'm not happy with the final decision of the director, there is no further avenue for redress. Is that right? Well, there are only two factors affecting the fees and charges. Number one, the fees and charges as set out in Schedule 2, and number two is about the proper working of the meter. And if the water meter is to be relied on for the fees and charges, then it's a technical matter. So on the face of it, it will not be a decision by the director as to the level of fees and charges, because there is an objective way of determining the fees and charges, because it's been set out in the bill. And of course, if it's about the functioning of the meter, then it's not the director who is making the decision. It's about the accuracy of the meter. And therefore, the bill already allows the consumer to ask for a testing of the meter, and if the meter is not working properly, then the liability would be taken up by the director. So we believe that there are already sufficient safeguards. So it's not about whether or not the director has been given the power to determine the level of fees and charges. So that should not happen. So it's not for the director to decide or determine on the level of fees and charges. But then is it appealable under Clause 22 if I think that the fees and charges are not reasonable? Can I lodge an appeal? Alright, even after the testing of the meter, if still the consumer thinks that he has been overcharged, then can he lodge an appeal under Section or Clause 22? Well, I'd like to understand a bit more about the question. So you think that you've been overcharged. So are you suggesting that the fees and charges under Schedule 2 are not reasonable, or is it that you think that the meter is not working properly, that's why you think the fees and charges are not reasonable? Well, both are possible. But then there might be other circumstances under which I might feel aggrieved. And if I think that you have been unfair in your fees and charges, and therefore I've overpaid, and under Clause 15, the director has the power to offer a refund. But if I still think that his decision is not correct, then can I lodge an appeal? And if you say that we are not able to lodge an appeal, then we are clear about this. So I'm just asking for a yes or no answer. So if you say that, that we will have to rely on the meter, but then the meter cannot speak on its own, and therefore, if a test will have to be conducted, but then in the end, the decision will have to be taken by the director, because he'll be issuing the demand note. So in the end, is the director of DMS, or is the director of EMS who will be issuing the demand note? Well, I think is the decision taken by the director, and if anybody feels aggrieved by his decision, then whether or not it's appealable. With regard to the supply of district cooling services, objectively, that is not a decision taken by the director, and therefore that is not included in this appeal mechanism. Maybe I can defer to my colleagues, Mr. C. Yes, thank you. I think the PAS was right, because under Clause 22, it would not include an appeal by the consumer with regard to the amount of fees and charges. But then if he feels aggrieved, then he can still lodge an appeal. Is that right? So you said that the person who is aggrieved by any decision taken by the director can lodge an appeal. I think there are several circumstances. That is under 7.1 BCD. And if anybody feels aggrieved, then you can lodge an appeal with the ombudsman concerning the appeal mechanism. So I think you're referring to B, C, and G under Clause 7. But then under 7B, if he has not honored his pledge, including the payment of fees and charges, then under the circumstances, the director will suspend or terminate the supply, then you can lodge an appeal. So is it that it has nothing to do with the fees and charges? No, I don't think that will be the case, because under the circumstances that I just described, that could also have to do with the imposition of the fees and charges. All right, indirectly, you can say that because of the fees and charges, you can still lodge an appeal. But then, still, under 22(1)(c), it's been made very clear. That is a decision to suspend or terminate district cooling services to a building. So, even if you lodge an appeal, you can only lodge an appeal against the decision to suspend or terminate district cooling services. You cannot appeal against the amount, because on the adjustment of the amount, according to the clauses as they are drafted, it has nothing to do with the amount of the fees and charges. So it's just an appeal against the decision to suspend or terminate the services. Mr. Alan Leung, in the event that something similar to what Mr. Wong Teng Kwong described happen, the user would of course refuse to pay. And if he refuses to pay, then of course the director would suspend or terminate the service. And in doing so, the user can lodge an appeal. And if you look at clause 30, the decision would be taken by the board, by the appeal board, and the board can vary or suspend the decision. So reasons will have to be given. So the board can confirm, vary, or revoke the decision. Well, maybe the meter was not working properly. That's why the calculation was wrong. And under these circumstances, that might help to deal with the question raised by Mr. Chair. But then I'd also like to discuss with the administration about the logic of the entire appeal mechanism. Mr. Chairman, if you look at clause 22, all right, clause 22 says that a person who is aggrieved by any of the following decisions and direction made by in respect of the person may appeal to an appeal board against the decision or the direction. And then under subclause A is a decision not to approve a person as the consumer of district cooling services for a building under section 4.4, and that decision obviously is to be taken by the director. Okay, and if you have to find a reason to explain why certain parties will have to be excluded from the appeal mechanism, and just now the chairman shared your thought, and apparently Mr. Shi also confirmed what you said was right. So in other words, DEF would mean that is a view of the director and therefore is not appealable. But then applying that logic to 22(1)(a) or B, these are also decisions by the director. How come under 7(d)(e)(f) that cannot be challenged? Also, if you look at H1 says that if the director has suspended district cooling services to a building under section 7(1)(b), C, D, E, F, or G, then it doesn't exclude D, E, F. So he may suspend the district cooling services to a particular building, and the approved consumer for the building may apply to the director for the services to be resumed. So even under BEF, he will still be able to make an application for the resumption of services. But then if you look at the entire mechanism, the logic doesn't follow, in the sense that for a building which has had district cooling services suspended, the approved consumer can always apply to the director for the services to be resumed. But then if you look at 22D, it refers to 8.2. That is, on the application under subsection 1, the director may resume district cooling services to the building. Okay, so if there is an application to the director for the resumption of services, but then under H2, if the director decides not to resume the services, and then DEF have been taken out, because under clause 22, D is drafted in such a way that, well, under Section 7(1)(b), C, or G, and if the director decides not to resume the services under 8(2), I do not understand the logic. I need an explanation. If you can come up with an explanation, of course, that's okay. But then just think about the pathway for appeal. In the end, under Clause 30, it says that the appeal board may confirm, vary, or revoke the decision or direction appealed against. So that's the purpose of the entire appeal mechanism. The appeal board does have this power to confirm, vary, or revoke. How come D, E, F have been taken out? And as I explained to the chairman just now, under Clause 8, if you look at subsection 1 and 2, you can see that under subsection 1, the consumer can apply for the resumption of services under DEF, and then under 8(2), if the director refuses to resume the services, you have singled out DEF, and the consumer cannot appeal under 22. So I do not understand. I need an explanation for that. Well, I can give you a further explanation, but then according to the discussion that we just had, I can summarize that in such a way that DEF are mainly looking at technical circumstances. And of course, for technical circumstances, why are we saying that under DEF, under 8(2), the consumer can still apply for the resumption of services? But then if the director thinks that, well, because of the repair and maintenance, the supply cannot be resumed right away, and therefore the consumer has already made an application, and the director, after looking at the situation for the suspension of services, the circumstances no longer apply. In other words, the repair has been completed and the supply can be resumed, and therefore the director can consider resuming the services. But then under B, if the consumer has failed to apply 7(1)(d), that is, the consumer has not given a guarantee, and now he is making this application to the director, and the director, after checking on the pledge made by the consumer, thinks that he has already met the requirement, then he can resume the services. But then just now the discussion was about B, C, D, and G, which are very clear. They involve the behavior or the conduct of the approved consumer, and then B, E, F do not mention the part of the consumer. And as Mr. Xi said, these are technical reasons, and of course, after completing or resolving the technical problems, the services will be resumed. I do not see why the director would insist on not supplying the services even after the completion of the repair works, unless it has nothing to do with the technical issue. So that's the explanation, because from the very beginning of this meeting, our legal advisor has reiterated about DEF, that those are the issues raised at the last meeting.
Chairman, so you can listen to our legal advisor first. Thank you. I understand Mr. Leung's concern. Mr. Leung has clearly pointed out that according to section clause 8 bracket 1, if the director, suspend the supply of services to a particular building pursuant to 7(1)(b) and so on, then the end user can apply to the director for the services to be resumed. The DFJ and the chairman just now was asking whether or not it was the director's decision is based on the behavior of the end user, and then the end user may apply pursuant to section 22. But if Mr. Leung's observation is right, then apparently clause 8 would mean that if someone pursuant to D, E, and F, apparently he can apply to the director for the resumption of service pursuant to section 8 bracket 1. Then why can't this person also, pursuant to section 22, feels that he is aggrieved? And why that he cannot appeal based on DEF? And it's not only that. I don't understand why DEF is inviolable. I was also saying just now that according to section 22, 1 bracket A, B, C, D, E, F, G, there are some provisions here which does not include the end user's behavior. I'm talking about logic here. Permanent Secretary, if you understand my logic, then please answer my question. Why is it safe 71 DEF are sacrosanct and cannot be violated? Unless the director is insane. Otherwise, when the scenarios under DEF arises, if it doesn't exist anymore, he still insists on not supplying the services. But if indeed you have such a director, then there will be someone who has been aggrieved. So what is the purpose of the appeal? And I'm pointing out here, if I may put it more bluntly, Clause 30 talks about determination appeal and how the appeal may be determined. And the power here is very extensive. Why is DEF sacrosanct? Where does it say that the end user who who is supplied with the cooling services, and that his behavior can be the basis of cannot be the basis of an appeal? If DEF were covered under the appeal mechanism, what is the problem? Someone may need to. I mean, there may be, I mean, you still have this appeal mechanism, although the number of people who may be aggrieved is smaller. Now, let me first of all reiterate that DEF is not sacrosanct or inviolable, but I'd like to explain that in clauses 7 and 8, whatever the circumstances, eventually we're talking about the suspension, the termination, or the resumption of supply of services. But they're not the same. Although the end result may be the same, eventually the services may need to be suspended or terminated. But the reasons are different. In clause 22, we are talking about appeal and what sort of decision may be subject to appeal. Now, the appeal board may vary the decision, and where there is a dispute. Let's say the end customer is disputing a certain point, then he can take his case to the appeal board. The appeal board can reverse the decision. However, there are certain things, for example, where there are breakdowns or there is a need to protect the property of somebody, then the technical issues have to be resolved according to the facts. And we've always emphasized that if there has been a breakdown, indeed, then there has been a breakdown. These are matters of facts. It's not that the appeal board cannot rectify that, but it's not suitable to deal with those scenarios under the appeal mechanism. Now, before you go any further, let me see if my understanding is correct. Our discussion this morning thus far is about why DEF and BCG are subject to different treatment as far as appeal is concerned. BCG is about the director who is of the opinion that the end user and consumer has not complied with certain guidelines, or his behavior would have an impact on the system. DEF, on the other hand, and the administration has explained that they only involve technical issues, which is about the behavior of the end user, and therefore there wouldn't be any possibility of the consumer being aggrieved. The problem is caused by technical reasons. Under BCDEF, the end user can still apply for the resumption of the cooling services. And thirdly, if the director doesn't agree, then he can appeal. Then why is it that we cannot also cover DEF? Mr. Lai?
係，多謝主席。咁或者咁咧，我覺得
Chairman, I think we've had a lengthy discussion about the technical issues. Well, let me explain once again that regarding the scenarios involving the termination and suspension services, we may have given the wrong impression that they belong to the same scenario, but that's not really the case. In some cases, we're talking about the director, accepting or not accepting a certain scenario. But if the system is broken down, this is a matter of fact, and I don't see how much room there is for the appeal board to deal with such a scenario. So it's not the intention that the appeal board, we should try to narrow the terms of reference of the appeal board. It's only a question of whether or not it's appropriate for the board to deal with those matters. I don't think we need to make a decision here. Having heard members' views today, perhaps you can go back and consider this matter more thoroughly and give us a written response. And if at the end of your deliberation you think that this is still appropriate, I understand that the scenario involving the suspension or termination of supply could be due to different reasons. One reason being that is caused by the behavior of the end user, whereas the others are only involve technical, breakdowns, and there's simply no dispute. So the system needs to be terminated simply because the pipe has burst. So there's no dispute whether or not the pipe has burst. So even if the matter were taken to the appeal board, the board would not need to deal with it. I mean, if the pipe has burst, then it's only right that the director order for the suspension of services. So perhaps we can hold this part, and you can consider this further after the meeting. Legal advisor. Beg your pardon, Chairman. The director has invited the administration to reconsider this part, and there are certain scenarios which involve matters of fact, and the system is broken down, then it's broken down, and it's not appropriate for the appeal board to deal with that. When the administration prepares the paper for our next meeting, I hope you will also consider clause 29 of the bill, which stipulates that the appeal board may authorize inspection of installations. If we're talking about, determining a matter of fact, let's say the pipe has burst, then according to clause 22, authorizing someone to inspect the installation and so on, what exactly is being inspected, and how will the result of the inspection fall under the terms of reference of the appeal board? If it involves a judgment regarding a matter of facts, or is it that the administration believes that this is under a different category that we're not able to identify? If I may briefly respond here, Chairman. Here we're looking at a series of decisions. For example, whether or not we have I think basically we are more focusing on C. So what is likely to happen may involve C. Failure to comply with the notice for improvement. All right, members have expressed their views, and now we may move on to clause 23. Permanent Secretary. Mr. Leung. Chairman. If the administration provides a paper for the committee, please also consider clause 23. Here you say that the a notice of appeal must be, comply with certain form and so on. So other than clause 29, which the legal advisor referred to just now, one can also see that the decision or the ruling of the appeal board, according to the thinking of this blue bill, will not make a judgment in regard of a matter of fact. He will listen to a factual witness and then make a decision. I'm concerned about the end consumer. I don't care what is the ground of the director. So long as this expand my service, then I should be entitled to appeal. You can't say that, well, if the pipe is burst, objectively that the pipe is burst and you will not allow for an appeal. Would it be the case that you are worried that if you allow for such appeals, then the number or the emergency situation will not be able to rectify it in time? But that's not really the case. You've stipulated in the course of the appeal the decision of the director will not have to be, put on hold. So I don't really understand. I really look forward to the paper that you will supply us at the next meeting, and please also explain to you what is the logic. Whether or not in terms of the policy or according to the provisions of this bill, or even in terms of logic, you need to give us a clear answer. So simply put, if we include DEF under the appeal mechanism, would that be impossible? And what would be the problems if we did that? All right? Clause 23. Clause 23 is about how to lodge an appeal, including the time limit within which the notice of appeal has to be lodged. Mr. Lai already said that under bracket 3, the notice of appeal must be in a specified form, and the specified form is explained in subsequent provisions which are to be stipulated by the director. So regarding the appeal mechanism under Clause 23, we've made reference of the Buildings Ordinance and other similar ordinances. Any comments from members? Mr. Tony Chair. I think the 14 days notice period, I hope that could be extended further. It is my observation that sometimes the end user could be the property management company, and if the appeal were to be lodged, it may involve, the end users who are leasing the units, the individual units in the building, and the property management company may have difficulties in getting consent from all the tenants or users. So I wonder whether or not the 14-day period could be extended.
And also to respond to the point about the appeal, all right, there are many engineers and so on. So why is it that for DEF, they are technical in nature? Why can't they be decided by the appeal board panel? Because they have 24 members coming from different disciplines, and many of them are professionals and engineers. Yes, well, under D, there is a flexibility. That is a longer period that the director may allow. So if the director thinks fit, he can always extend that. So does it have to be 14 days? No, that's not true, because the director has the room to allow for a longer period. The reason why we are putting 14 days, that might be good for the property management companies, so that they can ask the individual tenants and users to make up their mind as soon as possible. So with regard to the 14-day requirement, I think that's consistent with other pieces of legislation, and there is also a flexibility whereby the director can extend it if he thinks necessary. Okay, any further comments on 23? Well, if not, then 24. Chairman, on the appeal board panel, we have also provided that there are 3 categories of people, or 3 types. Well, under 1A, we hope that they can be barristers or solicitors, so that the chairman of the board should be a qualified legal professional, and B, as the district cooling services would involve a lot of professional expertise. That's why we would like to have 4 members with corporate membership of Hong Kong Institution of Engineers and so on. And another category would be people from the engineering sector. But then they would not be engineers in one or more of the electrical, mechanical, or building services disciplines. We hope that they can be broadly representative. So they would be engineers, but then in a discipline other than those mentioned in the earlier paragraph. And another category would be professionals. So in simple terms, we would like to get members of the public to join the appeal board panel so that they can also represent the public opinions. And then under subsection 2, we have also made it clear that for the engineering profession, the person has to have at least 10 years experience so that the board member will have sufficient experience. And also for the HKIE, for the corporate member, well, there are different disciplines. That's why we'd like to make it clear that in the appointment, the person's membership will have to be from one of the disciplines that we desired. So instead of just having an HKIE corporate member representing both the building services and also the mechanical engineering sector. And we would also like to make it clear that a public officer cannot be appointed. And also for the board member, we'd like to make it clear that the appointment period or the term of office would be no more than 6 years for the individual member. So it can be 3 plus 3, i.e. he can be appointed for 2 terms. And under what circumstances the member can also not be a board member, for example, after he has become a public officer. And also 6BCD also talk about the members becoming bankrupt or is incapacitated by physical or mental illness, or has ceased to be the of the capacity by virtue of which the member was appointed. For example, a lawyer, a solicitor, or barrister, and so on. So he will no longer be eligible for appointment. And then under E, we try to make it broader. That is a member who is otherwise unable or unfit to perform the functions of a member of the appeal board panel, then his duties will have to be terminated. And the secretary also will have to give notice in the Gazette of any appointment, reappointment, resignation, or termination of service or office under this section. All right, legal advisor, you have questions? I'd like the administration to clarify what under 24 with regard to the appeal board panel under subsection 4, it says that a member of the appeal board panel is to be appointed for a term of 3 years and may be reappointed where each reappointment is for a term of 3 years. But then just now you said that the maximum term should be 6 years. So can you make it clearer? Well, PAS, well, for this is not under the bill, but then the government's appointment policy is that for any individual joining a particular panel, then the longest term of office should be for 6 years. And under 4, well, for any member to be appointed, he could be appointed for a term of 3 years, and he may be reappointed for another 3 years. So 3 plus 3 would be 6 years. But then if you look at the wording here, there is no restriction that he can only serve up to 6 years, because it just says that for any reappointment, it should be for a term of 3 years. But then there is no suggestion that it should be just for one reappointment. In some cases, for example, if he's the chairman, then in some cases he might be allowed to serve a bit longer. But then the PAS just said that the norm is for 6 years. Is that right? Before I defer to Mr. Shi, maybe we should look at the English version. We'd like to make it clear, because in some cases the term would be for 2 years or 3 years. That's why we'd like to make it clear that is for any individual's appointment, it should be for an initial term of 3 years, and then he can be reappointed for another term of 3 years. But then in the English version, for each reappointment, it can be for 3 years, and then he can also serve for up to 9 years if he is reappointed twice. Thank you, Mr. Shi. I think the PAS was saying that the general practice was 3+3 as far as appointment to government boards and advisory bodies are concerned. But then I think the observation by the chairman was right. And that's also my drafting instruction. In other words, it's not restricted to 3+3. And for every reappointment, it could be for 3 years. As to the exact term of office, we can also clarify that after this meeting. Mr. Wong, I also agree with the view of the chairman. That is, the general understanding is that for any government appointment, it should be up to 6 years. So the general practice is for 6 years, but then in some exceptional circumstances, it can be longer. And if you put it here too rigidly, that is, if the maximum term is for 6 years, that might be a problem. So that's my view. And I'd also like to ask that, all right, under 23(1), D, not more than 4 members, each of whom is not from the engineering profession. All right. If someone has become an approved consumer of the district cooling services, then is there a chance or is there no chance for that person to be appointed as a member of the appeal board panel? PAS. All right. If someone is your consumer, would there be a conflict of interest if he also serves on the appeal board panel? PAS. This is about the appeal board panel. And then under D, for members of the public, if they are not from the professional disciplines, then there are chances that they might be serving in other capacities. But then for those sitting on the appeal board panel, there might be members of the public who might also be approved consumers or who might be working in a building management related professions. But then we are talking about the appeal board panel. If there is indeed an appeal case for the constitution of this panel, then we will also have to ensure that individual member of the panel will not have any conflict of interest. In other words, they will not be looking at cases involving themselves, and therefore in selecting members from the appeal board panel to form the actual panel, we will also have to follow the established procedures to ensure that there is no conflict of interest. I'm not sure if my understanding is correct. Please correct me if I'm wrong. Okay, for the appeal board panel, for any members under subsection D might be a consumer of the district cooling services. That's a possibility. But then if there is any case which might be related to him, or if there is a conflict of interest, then the appeal board will adopt effective measures to avoid any conflict of interest arising. So is that the practice in the future? PAS. Thank you. I can confirm what Mr. Wong said was correct. So that's the established practice. That is, we will have to ensure that there is no conflict of interest involving individual members. And before the appointment, as there will be no more than 4 members from each category, I believe that in selecting the members to join the panel, well, usually there would be 4 members, and therefore usually we'll be selecting 1 from the 4 members. And I believe that it should not be a problem to avoid any conflict of interest arising in the selection of members joining the panel. But then under D, you say that no more than 4 members, each of whom is not from the engineering profession. But then there is a possibility that all 4 members might be approved consumers of district cooling services, because you do not say that none of them can be approved consumers of district cooling services, and in the event there is an appeal case, alright, as all the 4 members would be approved consumers of the district cooling services, then there is no way that you can select any one of them without any conflict of interest. In other words, for people who are not from the sector, you will not be able to hear them. In making the appointment, I'm sure the Bureau Director will take that into account. Well, for approved consumers, it may happen to other categories, but then in making the appointment, I'm sure the Director will consider that. Yes, I agree. That might be one of the ways to deal with this. So the Bureau Director will definitely try to avoid that from happening by using their political wisdom. They would not be stupid enough to appoint all 4 members who are approved consumers. But then allow me to say this. So in the unfortunate event that all 4 members of this category are approved consumers, then there should be a split of 50-50. So in the code of practice, you will have to deal with that and make sure that this will not happen. Can that be done? PAS. Before we move on to the code of practice, I can also share with you our general practice. Well, this is not a new arrangement, because under the Building Services Ordinance, we also have to ensure that qualified professionals and community leaders will be appointed. And in choosing the community leaders, we would also like them to be broadly representative, and to come up with 4 members, all of whom are users of the district cooling services. Of course, that should not happen, because we'd like to have people who are broadly representative of the community. They should be independent, and therefore if we select members who are not from the engineering professions, and if all of them are approved consumers, then that would not be right. So in the unfortunate event that, let's say, out of the 4 members, 2 are approved consumers, probably after the appointment there might be a change in their capacity or status, and if some of them have become approved consumers, then on the next time around, when we select members to join the appeal panel, they will have to declare their interest by filling in the forms, and if there might be potential conflict of interest, then we will have to say that they are not qualified for the appointment.
Chairman, of the 4 members here, I hope some of them would actually be the end consumers of the DCS services, so that they can represent the interests of the consumers. So that even on the appeal board panel, at least that they are represented. But of the 4, I'm worried that all 4 of them are end users, and that would not be appropriate. But I also believe the Permanent Secretary, I'm sure the Director wouldn't be so unreasonable in making appointments in that manner. Perhaps we can deal with that by way of the guidelines or the codes. And I think we can also put this on record, that I have actually raised this issue. And I hope that in future you would also, be careful about such a possibility. Mr. Paul Chair, or Tony Chair, rather. According to clause 24, bracket 2A, that is a person who has been an engineer for no less than 10 years. So this is pursuant to B and C, but you can still appoint such a person by way of D. Of course, I hope, like Mr. Wong Ting Kong said, for D, it would be best we appoint people who are not engineers. But you may have engineers who don't have 10 years experience and they wouldn't qualify under B and C. And secondly, regarding the appeal board panel and its term, it is provided here that it should be for 3 years. I don't have any objection to that. I'm sure for other committees that the tenure is also stipulated to be 3 years. Would it be possible that you say that the appointment will be, for maximum of 3 years? I'm worried that, since the function of the board is to listen to appeals, then after 3 years, all the incumbents would leave, and then you have a new batch of members, and that may not be too appropriate because you have to appoint, new members. So how can you avoid that scenario? That is, could the appointments, be staggered? That is, although this is what is provided for in the bill. Why do you prescribe that it must be for 3 years? Could it be that they could be appointed for a maximum of 3 years? Let me respond to, first of all, the question regarding 1D. We said 4 members. We're not saying that they should overlap with other professionals. But in D, under D, we like to appoint people from the community so that they can represent different interests or different perspectives in respect of a case. So we want a more balanced view in the committee. And I don't think we need to worry that the views of the end consumers cannot be fully, expressed. Of course, the appellant can state his grounds, so will the EMSD, and we hope that there can be a board that can provide an independent opinion that is, objective. The proposed composition of the board is such that we have a majority of the members being professionals, because it deals with disputes which relate to technical issues. But still, in the end, we want a category of members who represent the community, who are independent, and so that for a lay member who doesn't have the professional expertise, how would they look at the issue which is being considered by the board? And that is our intention here. Regarding the term of members, namely 3 plus 3 years, and whether or not that is not flexible. Now, the appeal board panel comprises a panel of people. Every time we need to form a board, we would need to consider each and every member or to be selected, and whether or not there is any conflict of interest, in order whether that such a member has served close to 3 years already and is about to retire, and also whether or not there's a possibility that he may refuse to be reappointed for a second term, in which case, when we form the appeal board, we will bear all that in mind to ensure that all the members sitting on the board can serve the full term. I don't know how you make that decision. I'm just worried that there is a scenario where all the members are about to retire soon because they're all appointed for 3 years. I think here we are making reference of the arrangements for other committees and how the term is being prescribed. Here you said no more than 3 years and can be reappointed for no more than 3 years. Can we also retain the flexibility like that? Operationally, there might be a problem. For in other ordinances, do they have such an arrangement which I suggested earlier, that is reappointed for no more than 3 years. Yes, I've seen, indeed such provisions, no more than 3 years or no more than 2 years. I think members are concerned about the question of succession and whether there might be a vacuum, that is, all one batch of members would resign at the same time. And here, we're talking about each member who will be appointed for a term of 3 years and could be reappointed for another 3. But we've not rigidly required all members to be appointed in the same year, while there is such a possibility. I understand members' concern that we need greater flexibility. We can certainly, please consider that, yes. I'm just worried about the operational aspect. That is, the term is to be for 3 years plus another 3. Or I think we need the flexibility. You can, for example, wait until the first batch has served the term, and then you reappoint some for 2 years. I think, especially when there is an appeal, I think the board may call expert witnesses, and the appeal board may need time to listen to the appeal. And if the term of the member is about to expire at that point, then it might cause some problems. Any further questions regarding clause 24? We've scrutinized clauses 23 and 24. Do members have any comments regarding the English version of those two clauses? We've been referring to I think it has always been a habit to look at both the Chinese and the English versions of the bill. Mr. Secretary? Legal advisor would like to ask another question. I would like the administration to also answer this question. That is, whether there would be a mechanism. That is, if there are members on the appeal board, in other legislation, if the member doesn't want to, serve as a member, then he can simply serve a notice to the public officer concerned, indicating that he would like to resign. Do we have a similar provision here? 24/7 is about, resignation. But there is no provision here saying that a member may resign. Mr. Secretary? Thank you. As the chairman said, 27(4), when we drafted this subsection, our intention was the person could resign. As to whether or not we must spell out under clause 24 the circumstances under which he may resign, perhaps Mrs. C could explain. I think you can, the member could certainly resign even if you do not provide for that here. Clause 24 is the provision regarding resignation. 24(5). Oh yes, yes. So he may resign from his or her office by issuing a notice in writing to the secretary. So that is very clear. Any further questions? Any further comments regarding the English version of the bill? And for clause 22, the administration will go back and consider whether the appeals could be lodged on purely technical grounds. All right? We're now up to clause 25, which is about the composition of the appeal board. And I think this is similar to other ordinances. The director may, that is, it says here, within 21 days after receiving a notice of appeal, the secretary must appoint from among the members of the appeal board a panel. And we hope that the chairman of the appeal board would be someone with legal background, and the other 4 members must be appointed from the two categories of engineers and also a third category, which is the lay members. So altogether 4 members. For 25 bracket 3, we stipulate here that if a vacancy occurs in an appeal board before the hearing begins, then the secretary must, as soon as reasonably practicable, make an appointment from among the members of the appeal board panel to fill that vacancy. We've also provided under bracket 4 that the members of the appeal board may be paid out of the general revenue by any remuneration the FS determines. So that would be the provisions for clause 25. Strong thing call? Thank you. There are 2 structures under 25. First of all, we have the appeal board panel and the appeal board. The board is selected from among members of the panel. But here, my question is that if there is a vacancy arising in the appeal board, then you will fill that vacancy from among members of the panel. But there's a vacancy arising from the appeal board panel. Is there a mechanism to fill that vacancy? And secondly, I'm very concerned about 25 bracket 4, the question of remuneration. The determination of the remuneration is now to be determined by the FS. My question is whether or not the remuneration is in the form of a monthly payment, or is it to be paid on a case-by-case basis, and when a case is being heard, and that the member is remunerated according to the workload required. I think normally it will be based on the workload. I understand that for some non-government organizations or structures, such members are paid on a monthly basis. Thank you, Chairman. Let me answer your first question, and Mr. Lai could perhaps respond to your second question. Your first question is about the appeal board panel, and when there is a vacancy, how do we deal with that scenario? When we talk about the appeal board, there will be 5 members, and before a hearing and when a vacancy arises, we must fill that vacancy. Whereas for the panel, we're saying that for each category there should be no more than 4 members, assuming that for a particular category we have appointed 4 members, and if one of them resigns, how do we deal with that? In theory, since we say there should be no more than 4, then we can we can set it for 3. It all depends on the actual operation. If there are many cases and a vacancy arises, we certainly invite the secretary to appoint another one to fill the vacancy. But looking at 24 alone, it doesn't mean that when a vacancy arises, we must immediately fill that vacancy, because it's not the same as the requirement to form a quorum. Well, in the past, we rarely had a scenario where we immediately needed to fill a vacancy.
Yes, Mr. Lai. On the honorarium for the board members, well, we have to do so in accordance with the guidelines of the CSB. So for the time being, it's $920 for every session of the board meeting. So it depends on how many sessions will be required, but then that will also be reviewed on a regular basis, once every 6 months. I'd just like to know more about the honorarium. So is that on a case-by-case basis, or is that going to be a monthly remuneration? No, it's on a case-by-case basis. Mr. Tony Chair, I'd like to clarify further about the constitution of the appeal board. All right, under 2B, for the remaining 4 members, they must be appointed from 3 categories of members specified in Section 24(1)(b), C, and D. What I'd like to see is that at least one of them should come from the non-engineering sector, so that would be under D. The way it is now drafted, can that be reflected? Because in terms of the wording, I don't quite understand it. So you talk about the 3 categories. So in other words, at least one from each of the 3 categories. Is that right? Or can it be 3 members from one single category? PAS? Well, as to how we can interpret the draft, I'll defer to Mr. C. But then, according to our understanding, for the remaining 4 members, they have to come from the 3 categories. In other words, at least one from each category. So there might be 2 from a particular category. So that's the target. And Mr. C might wish to supplement. Yes, Chairman. In fact, the PAS interpretation is correct. In other words, well, at least one from each category, and then for the 4th one, he can come from one of these 3 categories. Well, in terms of the actual wording, I don't quite sure about the interpretation, but then thanks for the elaboration. So that helps me to understand it better. But then at least from the wording, it's not that clear. Maybe for those from the legal sector, they might find it more easy to understand. But then as far as I'm concerned, I don't think that's very clear. So can you clarify it a bit further so that for those who are not from the legal profession, they would find it easier to understand? Because for those of us who are not from the legal profession, I do not think it's readily understandable. Yes, my interpretation is the same as you, Mr. Chair. Well, for the 3 categories, so long as you can get 4 from the 3 categories, there is no mention that you will have to have at least one from each of the 3 categories. I think if you can add in the words at least one from each of the 3 categories, that would be clearer. Mr. C? And if members would like to make it clearer, then of course we can consider for making it even clearer in order to reflect the intent. So it's not very clear that you have to have at least one member from each of the 3 categories. I think it's better if they can clarify it further, if that does not contradict with the original intention. All right, so can you make it clear? So for the 4 remaining members, at least one from each of the 3 categories. And of course, there can be 2 from one of the 3 categories. Okay, 26 now. PAS on the proceedings of the appeal board. Yes, 26 is about the proceedings of the appeal board. We have decided that the quorum for a meeting is 3 members, one of which must be the chairperson of the board. And then subsection 2. So at the time of the appeal board meeting, if there is a question to be determined, then it should be determined by a majority of those members present. For example, out of 5, if 3 were present and 2 were absent, then we believe that in the end, we should take the majority decision by those members present as the determination of the board. And subsection 3 says that if there is an equality of votes in respect of a question before an appeal board, then the chairperson will have a casting vote. And then subsection 4 will have to be read in conjunction with section 28. In simple terms, at the time of the meeting, if a member decides to resign, or if for other reasons he is not able to attend, then if there are less than 3 members attending the meeting, then we will have to reconvene the meeting. But then if one of the members, and of course he must not be the chairman, all right, if he resigns, then the board will continue to perform its functions and the proceedings will still be valid. And then under subsection 5, it says that in performing their functions, the members of the appeal board have the same privileges and immunities as a judge of the court of first instance in civil proceedings in that court. And subsection 6 talks about a person appearing before an appeal board as a witness, a party to an appeal, or a representative of a party to an appeal is entitled to the same privileges and immunities as he or she would have in civil proceedings in a court of first instance. And subsection 7 says that subject to this part, an appeal board may determine its own procedure. So that's the essence of the clause. All right, clause 26. Any comments? If not, then 2526 English version. Any comments? If not, then 27 PAS. Thank you. 27 is about the hearing of appeal. The chairperson of an appeal board must notify the appellant and the director of the date, the time, and the place of the hearing, at least 14 days before the hearing. And then the appellant may be represented by a barrister or solicitor of or an individual authorized by the appellant. And then the director may also be represented by a barrister or a solicitor or a public officer. We have also made it clear that the appeal board may engage a barrister or solicitor to attend the hearing of an appeal to advise it on any matter relating to the appeal. Subsection 4 also makes it clear that the hearing of an appeal must be, as far as possible, open to the public, unless the appeal board determines that there is a good reason for it to be held in camera. And this requirement is no different from any other appeal boards. We have also made it clear under subsection 5 that an appeal board may, by a notice signed by the chairperson of the board and issued to a person, to direct the person to attend before the board and also to give evidence or to direct the person to produce documents. And no person to whom a direction is given is required to give any evidence or produce any document that tends to incriminate the person. And then subsection 7 also makes it clear that if a person fails to comply with the direction under the provision to attend, then he commits an offense and is liable on conviction to a fine at level 3 and is $10,000 under the current rule. Legal advisor, you have questions on 26? Yes. Well, under 26 subsection 2, it says that a question before an appeal board must be determined by a majority of those members present at the meeting at which the question is to be determined. So according to my understanding, in fact, if you look at the appeal board, a total of 5 members will be attending, including the chairperson, and then 4 members. And then one will have to, well, what they will have one each will be from the 3 categories. But then if you look at 26.2 now, in fact, for the members present, the majority of them will be able to make a determination on the question before them. So I'd like to clarify a situation. Would there be a situation whereby, all right, the chairperson will be there, and on this occasion, you may have the chairperson together with member 1 and member 2, and then they will make a decision. And then they may not be able to complete everything in the first hearing, and then in the second hearing, you may have the chairperson with member 3 and 4. If that is the case, then by the end, So at the end of the day, who will be qualified to make a decision or make a determination on the appeal case? So at the time of the decision, whoever is present will be able to make a determination. Is that the case? PAS? Well, let me first say a few words about our intention. All right, we talk about the quorum. So 3 will form the quorum, and if any member fails to attend, then it means that he has not heard the deliberation at the meeting, and if he is not present at the deliberation of the hearing, then will he be able to form the majority of the meeting? Well, only those who are present will form the quorum and the majority of the meeting. But then I would like to defer to Mr. Lai, because as far as the EMSD is concerned, it is responsible for not just this appeal board, but also others. So maybe Mr. Lai can also tell us exactly how it works. Mr. Lai, well, generally speaking, for appeal boards like this, by the time when they make a decision, only those who are present will be able to make the determination. So only those who are present at the time of the decision will be able to make the determination. But of course, in the process, there might be members for one reason or another. Usually they would be attending all the meetings according to our past experience. So very rarely would there be a special situation whereby some members would attend one meeting but not the other. Usually, we would try to make sure that all members will be able to attend. So we'll try to schedule the meeting so that all members will be able to attend. But then for some ad hoc situations, if some members are not able to attend, then the relevant documents would also be sent to the members concerned. And when a determination has to be made, then of course the determination will be made by a majority of those members present at the meeting. Any further questions, Legal Advisor? Would the administration consider this? The reason why I raised this, that's because under Section 36 of 106 is about building energy efficiency, and there is also an appeal board under that ordinance, and under subsection 1 of Section 36, it is made clear that it's about the quorum of the panel. So 3 members will form a quorum, and then subsection 2 goes on to say that, well, if there is any question to be determined, then a majority of those members will be making the decision, instead of having a majority of those members present at a meeting. So after reading that, well, in view of the fact that, well, there should be 5 members forming the panel, and the panel might not be able to make a decision after one meeting, so there would be transcript recording the arguments put forth by the parties to the hearing, so that for those who are not present, they would still be able to go through the proceedings. So in these circumstances, if a decision has to be taken, so does that mean that we are talking about the majority of the 5 members, or the 3 attending will then be able to make a decision? So that's the background reason why I raised this in the first place. So can the administration explain what their consideration is? PAS.
Thank you. When we drafted bracket 2, of course we've made reference of the approach adopted in other ordinances. Of course, Cap 610 is one of the ordinances that we made reference of. In the actual operation itself, if we put it very vaguely and say simply say a majority without having discussed this, and we've also, of course, there are other ordinances other than Cap 610 which deal with appeal panels, and here we decided that the majority of those present at the hearing would be the better option. I think the Secretary is right. Basically, we're talking about members present who had participated in the deliberation. It is more appropriate for them to make that decision. Mr. Chair, thank you. by present, we're talking about the meeting during which the decision was made, but the member might have been absent during earlier meetings. The Permanent Secretary is saying that even if they have been absent, then they would still have been given the relevant information. I mean, he may be present at the last day of the hearing on which a decision was made, but he would have read all the minutes and so on, and he has been fully informed. So if that could be established, I think it's very clear that the board should have 5 members. It just so happened that 1 or 2 might, at the last meeting when the decision was to be made, was absent. But then a decision has to be made. So logically, it would appear that there is some confusion here. Since all 5 members, since the 5 persons are members of the appeal board, and all 5 are fully familiar with the case, why is it that only members who are present on the day the decision was taken, and that we should count the majority amongst those members? Actually, the number 5 is very clear. Of course, during the last day of the hearing, you may not have the opportunity to give him the relevant papers. Now, at the time when of the meeting when the decision was made, or very often, my impression is that having heard all the evidence, the members of the appeal board would deliberate further on the evidence and then come up with a decision. So my question is very simple, Chairman. I mean, there has to be 5 members. Why then is it not the case, not that we should have the decision of all 5 members? Permanent Secretary. As the Chairman said, I think both approaches have their, pros and cons. The MSD has dealt with different, the operations of the different appeal boards and feel that this is the right arrangement or approach. Although the papers can be circulated to the members and they should be kept informed. But one important part of the procedure for the appeal board is that the matter should be deliberated at a meeting. Assuming among the 5 members 1 is absent, assuming they has read all the papers, but he is not able to be present at the meeting to participate in the deliberations, very often the decision is made after the deliberation, and it's not simply a question of members looking at reading the papers and then be able to make a decision. So in the light of our actual operations, an important element here is that the member must have participated in the discussion at the meeting. But if only 3 members attended the meeting, although a forum was formed, all members may not be able to come on the same day. We've discussed this with the MSD, and they've told us that they will try the best to arrange for a day for all 5 members to be able to attend the meeting. But then if a certain member cannot end up attending, then it can't be helped, but at least there should be a quorum of 3. But it is more reasonable that only those who have participated in the deliberation can make the decision. Because those who have not participated may not have heard part of the deliberations. You may have, different perspectives by different members of the board. Mr. Lai. Let me elaborate further. Of course, Mr. Chair is correct. The minutes of previous hearings and meetings, of course, will be circulated to all the members. At the last day of the hearing, when the concluding submissions have been made, and after that the members will further deliberate and come to a decision. Normally, the committee or the board will invite a legal advisor to give legal advice to that board during the final, deliberation before a decision is made. And even if the member had participated in earlier meetings, but if he were absent, on the very last day of the hearing, he might have been sick or might need to attend to other urgent businesses, then it would not be appropriate for him to take part in the decision-making process. So we therefore believe that the only members who are present at that very last meeting should make that decision. Well, in that case, at a meeting, you will need to make a decision. I believe at the meeting the members would need to state whether they are for or against a particular decision. If we adopt that principle, for members who are not present, people may not find them credible. If you have 3 members present, the other 2 were not, then what's going to happen? Nothing can be done according to what you are proposing here, because the decision of the appeal board is final, and it is not subject to any further appeals. Could somebody take this further to the court? Mr. Chair is saying that the board may uphold the appeal, but those who are absent disagree. And if you count the opinion of those 3, then the appeal should have been turned down. But then, according to the views of those present in the meeting, the appeal is upheld. Well, there are other ordinances which provide for appeal boards, and according to our experience, we've never encountered a scenario which the members have suggested. Normally, the members that we appoint should be able to appoint, have always been able to turn up at the hearings. We only also schedule a meeting if we are sure that all the members can attend. We would ensure that all members can participate in the final day of the hearing where decisions are to be made. Of course, you suggested the very exceptional circumstances where 2 members are not able to be present at the last meeting, at which time I think we can certainly arrange for another date for the board to conduct a hearing. Mr. Wong Ting Kwong, I don't want to get bogged down, with this any further. But if you, take the example of our panel discussions, very often during the deliberation stage, many of the members are absent, and only at the time when the vote is taken that they all rush back to participate in the voting. According to this bill, I think the meetings of the appeal board is open to the public, so everything is transparent, and anyone who is interested in the case would be able to be informed, and everybody can see what the members of the board is doing, whether or not they are lazy and so on. So they would have to be responsible for their own behavior. Now, in the course of the hearing, sometimes the chairman and 2 other members may just form a quorum, and all 3 hold the same view. But at a later stage, at the time the decision has to be made, those 2 who had not been those 2 are not present, whereas those who were absent previously were present at the day when the judgment was made. So you have 2 versus 1. And these 2 who are present hold an odd contrary to that of the chairman. Originally you had 3 versus 2. Now eventually you end up with a scenario of 2 versus 1. And then the outcome of the whole hearing could be reversed. So for the 5 members, I think the whole appeal board will have to be responsible if that scenario were to arise. I think the eventual decision has to be made by members present at the hearing. If you say that the final decision to be made by those who were absent on the day of the decision, then the appellant may also object by saying that on the very last day when the important decision is made, those members were not present. But the MSD has many appeal boards. I'm sure you have a lot of experience in dealing with such scenarios. Well, many people may not understand why the arrangements are different for different, boards and so on. So I'm sure the administration has made reference of other legislation and so on. If there are objective, grounds, then I think we will be convinced. But we're not given any such objective reasons. I'm not saying one system is necessarily better than another, but the legal advisor has asked a valid question. Why is it that the arrangement is different according to one piece of ordinance and it's not the same in this one? Any other views regarding clauses 25 and 6 and also the English text? Except for 25 2, you should stipulate more clear that it should be at least one from each category. Well, it's now 10:30, and I think we should adjourn at this stage. And I don't think we have too many clauses left yet, but we still have to look at the schedules. Date of next meeting is the 16th of February at 8:30. AOB, could the Secretary also tell us about the visit? The members have suggested that we should organize a site visit. We've now scheduled a tentative date, which is the morning on the 6th day of the Chinese New Year. We will circulate a notice to members to see how many of you will attend. That will be the 24th of February in the morning. The Secretary has proposed many dates, but we're not able to we don't have a sufficient number of members, attending. So I hope we really can make it on the 24th. Thank you.